Deputy Public Defender Oscar B. Rowe here with today's lesson on California Penal Code Section 182, Criminal Conspiracy. I'll discuss the elements of the crime, provide some examples, and discuss some defenses to the crime. The jury instructions for this crime are contained in Cal Crim number 415. In order to convict someone of this crime, the prosecution has to prove 1. There was an agreement between two or more people to commit a crime. 2. At least one of those people committed an overt act in the furtherance of that agreement. Let's unpack that first element, the agreement. The law requires proof of a meeting of the minds, a shared understanding to commit a specific crime. This agreement doesn't have to be formal or even spoken out loud in detail. It can often be inferred from the actions, the circumstances surrounding the people involved if there's clearly a common criminal goal. Consider this scenario. Two people, we can call them Joe and Hunter. These are completely fictional characters, and this story is made up. Hunter has access to large amounts of illegal narcotics. Joe has access to police protection. Hunter decides to enlist Joe in his narcotics distribution network. Joe is unemployed and needs money. Joe and Hunter discuss using the police protection of Joe to transport the drugs to other dealers. They're seen together multiple times talking about this illegal narcotic distribution. Hunter, being a crackhead, even records the conversations on his laptop. That pattern of behavior, their preparatory actions and their conversations, show an agreement to distribute illegal narcotics. These cases are often not as cut and dried as this one. They often hinge on piecing together evidence to build a picture of shared intent. Once the agreement has been made, you need the overt act in furtherance of the conspiracy. This is any action taken by one or more of the people involved after the agreement has been made, but before the actual crime is finished. And its purpose has to be to help advance the conspiracy's goal. In the Hunter and Joe scenario, Hunter now meets up with Joe while carrying a briefcase containing illegal drugs. Joe is made aware of the contents of the briefcase and says he is ready to help distribute them. This is clearly an overt act toward committing the crime. Unbeknownst to Joe, Hunter left his computer at a shop for repair, and the clerk hears the file of Joe and Hunter discussing the crime. He turns that information over to the police, who take action on the conspiracy to commit the crime. It's crucial to understand that the overt act itself doesn't have to be illegal. It just needs to be a step taken towards committing the agreed-upon crime. It's like tangible proof that the agreement moved beyond just talk into actually doing something, even if that first step seems minor on its own. One question I get asked at parties is, what if I'm just around people who are planning something bad? Does that automatically pull you into a conspiracy charge? Simply associating with people who are talking about or planning a crime, or even being there when they take some steps, while not a good idea, doesn't automatically make you a conspirator. Free legal advice. Get out of there as fast as you can. And another point here is, you don't necessarily need to know every single person involved in some big conspiracy ring. As long as you agreed with at least one other person to commit the crime, you could potentially be looped into the broader conspiracy charge. If someone is facing a conspiracy charge, what kind of criminal defenses are available? One is challenging whether an agreement actually existed in the first place. Second, arguing that no overt act was ever committed. Third, showing that the person effectively withdrew from the conspiracy before any overt act happened. How does someone actually demonstrate they never agreed to anything illegal? Glad you asked. Remember, the burden of proof is on the prosecution. They have to prove beyond a reasonable doubt that you intentionally agreed to commit a specific crime. So, a strong defense involves presenting evidence or poking holes in their evidence to show that no such agreement happened. For example, imagine Diane is shopping with Nancy, and Nancy suddenly, out of the blue, steals expensive jewelry. If Diane had zero prior knowledge, didn't plan it with her, wasn't involved, her mere presence doesn't mean she agreed to the theft. As a defense attorney, I focus on dissecting the prosecution's evidence. I look for innocent explanations for shared activities or communications, anything that shows a lack of specific criminal intent for that crime. What about the no overt act defense? It's definitely a critical element. Just agreeing isn't enough for conspiracy. Someone involved has to take that concrete step, that overt act to move the plan forward. A successful defense can be showing that there might have been a discussion, maybe even some planning, but nobody actually did anything tangible to carry it out. No overt act by anyone involved means no conspiracy crime. And the third defense is withdrawal from the crime. I would need to show how someone can legally back out even if they initially did agree. The timing is absolutely critical. The basic idea is if you initially agree to commit a crime, you might be able to avoid liability for conspiracy if you clearly tell the other conspirators you're out. You have to communicate your withdrawal clearly and unequivocally. You have to do it before anyone involved commits any overt act. Or, for example, let's say Barry and Joe talk about stealing a car. But before either of them does anything, no car scouted out, no theft tools obtained, Barry tells Joe, "Look, I've changed my mind. I'm out. I'm not doing this." If he communicates that clearly before any overt act happens, he likely has a solid withdrawal defense. But let's say Joe had already bought gloves and a lock punch specifically for the theft before Barry told him he was backing out. Then it's too late for the withdrawal defense. Let's discuss the consequences for someone is convicted of criminal conspiracy in California. The penalties can be quite severe, and they're generally tied directly to the seriousness of the crime they conspired to commit. If the conspiracy was to commit a felony, the punishment for the conspiracy itself usually mirrors the punishment for that underlying felony, and they receive same sentence as if they'd actually done the crime. Conspiracy to commit a misdemeanor is a wobbler, meaning the prosecution gets to decide whether to charge it as a misdemeanor or as a felony. They'll look at the case details, the person's criminal history, things like that. California law does allow for expungement in some cases. Generally, if you successfully complete your probation or serve your jail time for the conspiracy conviction, you can petition the court to get it expunged. It doesn't erase it completely, but for many purposes, like most job applications, you can legally say you weren't convicted. Conspiracy is different than being an accessory or an attempted crime, which are covered in other lessons in this class. I'm Deputy Public Defender Oscar B. Rowe, and that was your lesson on California Penal Code Section 182, Criminal Conspiracy.